I want to welcome each of you to today's presentation, where we're going to discuss the many numerous changes to Virginia's employment laws, some of which have already been enacted and some that were just recently enacted as of July 1, the vast majority of those. And for purposes of planning, we have a period of time at the end of the webinar today for questions and answers, and we also have a chat box that you can type a question in if it's something that you don't feel can wait till the end of the seminar, or you just don't want to forget your question. I'm going to ask everyone to go ahead and mute your microphone. You can have your camera on or off, whatever preference you have. And I will, for another disclaimer, we are recording this, and the recording will be also available on our website. So without further ado, let's talk about all the numerous changes that are coming into play for Virginia's employment laws. Okay. The first change is to Virginia's minimum wage law, the Wage Payment Act and the minimum wage law. Most Virginia employers did not have to pay much attention to the Virginia Minimum Wage Act because it was full of exclusions, and almost all the employees were covered by the Federal Fair Labor Standards Act that most of you have heard of. But they recently changed it, and it now applies to almost all Virginia employers. The biggest change, however, was the increase in a Virginia minimum wage. Virginia historically simply followed the federal guidelines, and so whatever the federal was, that was what we did. We now have our own minimum wage law. So, oops, I'm skipping a slide. There we go. Okay, back at it here. All right. So Virginia is now joining many of the states that are trying to creep towards $15 an hour. They've done it on a progressive sliding scale. Because of COVID, what would have gone into effect on January 1 is now going to go into effect May 1, and that's the first bump up from the current rate to $9.50 an hour. So that's the first trigger date. Then thereafter, each successive January 1, you see the incremental changes going to $11, $12, $13.50, and finally $15. There's a little caveat though, and that is that the 2025 and 2026 increases will not become effective unless they are reenacted by a session of the General Assembly prior to July 1, 2024. So they put them in there, but then if they're not reenacted, they go away, which would leave everyone at $12 an hour. So frankly, none of us have a crystal ball. We don't know what the General Assembly is going to look like. In 2024, there will be 2 elections, I think, prior to that time, which would change perhaps the makeup of the House of Delegates and the Senate. And so we'll just have to adopt a wait and see. But we know for sure we're going to get to $12 an hour. So that's one thing to start preparing for. Okay. Included in that wage payment law is now a private right of action, which means a way of bringing a lawsuit, both individually and collectively, for violations of the Wage Payment Act. There's a 3-year statute of limitations, and it comes with what we lawyers call the full panoply of remedies, which is the amount owed that was actually unpaid wages or overtime that should have been paid, liquidated damages, which means they double that amount, prejudgment interest, and attorney's fees and cost. And if the violation is deemed to be willful, such that it was a knowing failure to pay wages, then it's, you'll hear it called treble sometimes, but it's triple the amount of wages due plus reasonable attorney's fees on top of that. So it's patterned very much like the Fair Labor Standards Act, which is the federal law, but now it's Virginia specific. And why this is meaningful in many ways is it gives the employees a new forum. Typically, if the employee was suing under the Fair Labor Standards Act, that meant they were in federal court. Federal court is not as friendly of a forum to plaintiffs generally. It's a much more friendly forum for the defendants. It relies on a heavy motions practice. There's many opportunities for defendants to seek pretrial dismissal. Those same opportunities don't exist at the state court level. So it's much more likely that the employer is going to incur more attorney's fees and cost in defending an action in state court than they would in federal court. And there's a much higher chance that it could get to an actual trial versus being diverted away on a pretrial motion to dismiss or a summary judgment proceeding. Okay. There's also another requirement. Most employers probably already give this information out because most employers either use a third-party payroll service or they use their own internal software. But evidently this was, you know, a remedy or solution that I didn't know there was a problem to. But it actually went into effect this past January, and that it lists the information that must be on a pay stub. And that is not only obviously the employer's name and address, but the number of hours worked in the pay period if the employee is hourly, the rate of pay, the gross wages paid, and then the amount and purpose of any deductions. Again, I think most employers already do this. There was some back and forth, and they had to do a little fix on the number of hours worked. For your salaried people, most salaried people don't have an hours worked categorization on their pay stub because their salary is irrelevant, frankly, to the number of hours worked. And initially, the law was still going to require an entry for hours worked. They have since fixed that since it was brought to their attention that it really wasn't very practical. But just be aware of that and make sure that your pay stub that your employees get, whether it's a paper stub or an electronic statement, meets these requirements. A big area of focus for the General Assembly this past session was what they call worker misclassification, and that is whether someone's truly an employee or whether they're an independent contractor. And apparently the powers that be in the General Assembly thought this was an area that was being abused by employers and that many people were being classified as contractors when in fact they really were employees. So now there's a legal presumption in place that anyone who works for remuneration payment is an employee, and that contract cannot, that presumption cannot be contracted away. And I'll get to some of the criteria they look at in a moment. But again, it creates a new cause of action, a new private right of action that would allow for all the actual and compensatory damages, and again, attorney's fees. The attorney's fees provisions can't be understated. You're going to see that as a theme when I address many of the other laws that they've created. For almost all the new enactments, the General Assembly put in attorney's fees. And in Virginia, prevailing party does not necessarily get attorney's fees unless there's a contractual provision that says they get them, or unless there's a statute that provides for attorney's fees. So it kind of gives a bit of an incentive to those people representing the employees to bring these actions, because now they have a way of recouping attorney's fees on top of all the other forms of damages. Okay. There's also included in the misclassification laws a ban on retaliation. So if there's someone who reports or threatens to report that they've been misclassified, you cannot retaliate against that person. That in and of itself creates a separate right of action. In the construction fields, there's joint and several liability for construction contractors and the subs. So this is a big issue if you are a general contractor, or even if you're a sub who has subs underneath of you, because you can be held liable for the misclassification of a worker that created by your subcontractor. So it's making you, if you're the contractor, police your subcontractors, excuse me. And for repeat offenders and those contractors who get Virginia government contracts, there's one of the penalties for repeat violators is you will be debarred and no longer permitted to get the contracts. Okay. There's some new whistleblower protections in place that many lawyers predict will be a new hotbed area of litigation that didn't exist in our state courts before. This went into effect July 1, and it prohibits employers from discharging, disciplining, discriminating against, threatening, penalizing, or retaliating against any employee who engages in the certain protected conduct. What is protected conduct? Well, if the employee or someone on that employee's behalf reports in good faith a violation of state or federal law to a supervisor, a governmental body, or a law enforcement official, that's protected conduct. If the employee is requested to participate in an investigation, a hearing, or an inquiry by a governmental body or law enforcement, or if the employee refuses to engage in a criminal act that would result in criminal liability. All of those things are deemed protected activity. So an employee could allege that he or she engaged in that type of action and that their employer then demoted them, disciplined them, discharged them, or took any other action against them. More things that are banned and considered conduct that is prohibited. Refusing to perform an order by the employer that would violate state or federal law, and the employer has to inform the employee has to inform the employer. That's the reason that they're refusing to carry out that order from the employer. Testifying before a governmental body or law enforcement official concerning an investigation, hearing, or inquiry into a legal violation. There's a 1-year statute of limitations to file a civil action. So that's a little bit shorter than typical. Most default statutes in Virginia are 2 years. This one only has a 1-year statute. And again, all the types of remedies that you see in a typical civil litigation, but also including injunctive relief, which would be a court order to stop certain behavior, is included in the list of remedies. This one's gotten a lot of interesting feedback from attorneys and even some employers. There's a new prohibition on non-compete agreements for low-wage earners. And the most interesting part is what Virginia defines as a low-wage earner. Non-competes have been the source of much litigation simply because there's judicial interpretations of what's overbroad and what's not overbroad. There's not really a statute addressing it. Well, now the legislature has stepped in and said that an employer cannot enter into, enforce, or threaten to enforce a covenant not to compete against a low-wage earner. The law defines what a covenant not to compete is, and it's one that typically restrains, prohibits, or restricts the person's ability following their termination to compete with the former employer. And any covenant that restricts an employee from providing a service to a customer or client of the employer, if the employee does not initiate contact or solicit, is also prohibited. Because some of the non-competes were drafted very broadly that says basically, even if our former client comes to you in your new place of employment, you can't accept the work, you'd be violating the non-compete. Well, now, in the case of the low-wage earners, and I'll tell you about that in just a second, you can't have these agreements. If you already have those agreements in place, they're valid. These are for agreements entered after July 1 of 2020. So just be aware of that and check your agreements if you use those. What the law does permit is non-disclosure agreements and confidentiality agreements, things designed to protect your trade secrets. Okay. So there's a couple of things you need to be aware of. Not only, again, have they created a new law with a new cause of action, which gives all the civil remedies. And again, it's a 2-year statute of limitations, and it tells you when the 2 years runs, either from the date the non-compete was signed, or the date the low-wage earner learned of the covenant, or the date the employment is terminated, or the date the employers take steps to enforce it. So the latter of. So it's not, it could be slightly longer than 2 years in time, certainly from the date the agreement is signed, depending on the facts of each case. A court can void that non-compete and award the damages that were incurred. And in this one, they expressly include expert witness fees and, again, reasonable attorney's fees. The Department of Labor and Industry can fine the employer $10,000 per violation. So that's pretty hefty. You now have another posting requirement. Many of you have this big multi-poster in your break rooms that combine Virginia and state laws. There's now another requirement. I check the Virginia Department of Labor and Industry pretty frequently, and I have not seen their sample poster. So what you can do in the meantime is post the actual law, because that's what it says. You're either required to post a copy of the law or an approved summary. So I'm sure the Department of Labor and Industry will come out with a summary soon, but until they do, it's the new code section. If you need it, I can get it to you later. You simply print it out and post it in your break room in the typical place where you post those type of documents. And of course, there's a penalty for not posting it. And of course, first time they'll give you a slap on the wrist, but at the second time, they're going to impose a $250 penalty. After that, a penalty not to exceed $1,000. Okay. So what is a low wage earner? You just jump right in. You're going to see right there in bold. For starting July 1, 2020, Virginia considers a low wage earner anyone earning $59,124. How did they come up with that figure? They're using the average weekly earnings, and they have a look back period, a 52-week look back period, or actual numbers worked if less than 52. So it says an employee whose average weekly earnings are less than the average weekly wage for the Commonwealth. They calculate that by looking at the Virginia Workers' Comp Commission wages. And so according to the Virginia Workers' Comp website, that average weekly wage was $1,137. When you annualize that out, that's $59,124. I have seen in the past non-competes for people making 35, 40, 40,000 a year, depending on what the trade was involved. So all of those going forward, if they were signed after July 1, would no longer be valid. So just be aware of that, because I think some people don't think 59,124 is low wage, but the General Assembly does, and that's what you have to be concerned with. A low wage earner also includes your interns, students, apprentices, and trainees, whether they're paid or unpaid, at a trade or an occupation. They also include independent contractors. Again, all these things would mean that these non-competes are barred. So, but the one exception is that there are employees whose earnings are derived in whole or in part from sales commissions, incentives, or bonuses. Typically your salespeople are not low wage earners. So they got exempted from that. And generally, their salespeople are generally exempt from many of these type laws. I know they're exempt from like the FLSA, those type things. Some of the more talked about changes concern the Virginia Human Rights Act and a new law called the Virginia Values Act, which became incorporated into our Virginia Human Rights Act. Prior to the new changes, the Human Rights Act was very limited. Most lawyers didn't use it or do anything with it because it only applied to employers who had 6 to 14 employees, and it banned discharge, not other forms of employment action, just discharge on the prohibited bases that were deemed discriminatory, such as race, color, religion, national origin, gender, pregnancy, those type things. For age discrimination, that law applied for the 6 to 20 range. And I think what served as a deterrent, frankly, to most employers is that there was a remedy which is limited up to 12 months of back pay, and then 25% of that back pay award was awarded as attorney's fees. And it was generally cost prohibitive. It would cost an attorney more to bring that action and recover that money in actual attorney fee time. And so you didn't see many of these causes of action. They're extremely rare. The new act. Now you're going to see the floodgates, as people call it, of litigation in the state courts. It's a new powerful tool because, again, most discrimination laws were founded on the federal laws we refer to as Title VII. And again, that meant that the litigants were in federal court, which is a very different legal landscape. So now the new law broadens employer coverage, adds protected classes, and extends liability for actions other than discharge. We'll talk about that in a moment. And again, a new private right of action with essentially unlimited damages and attorney's fees. And there are some new requirements concerning reasonable accommodation for pregnancy, childbirth, what they call related medical conditions, and lactation. So how do they broaden employer coverage? Well, employers who employ 15 or more for each working day in 20 or more weeks are covered. That also includes employment agencies, labor organizations. They were not included before. State agencies, institutions, boroughs, all the groups you see listed there now come under the coverage of that act. It also has a public accommodation feature. Again, it's patterned very much after the federal Title VII law. New protected classes that I think some of these are going to have to be worked out in court. You know, exactly what they mean and how they're going to be interpreted remains to be seen. I have yet to see a new act. We try to follow it, any new lawsuit, excuse me, over this, but they're coming. One of them is a broadened definition of what it means to discriminate because of race, and that refers to hairstyle. They've broadened the definition and claim it says the law reads that because of race or on the basis of race are defined to include because of or on the basis of traits historically associated with race, including hair texture, hair type, and protective hairstyles such as braids, locks, or twist. I think it's just walking through that, you can see where there's going to be some issues, because what may have historically been associated with one race now may be worn by many races. And so what does that mean? Does that mean that if a person is wearing a hairstyle that was historically associated with race A, but they're in race B, does that mean they can be discriminated against, but the first race cannot? I mean, it raises a lot of questions. The other one probably comes as no surprise because of the federal act. People thought it was coming to this, and that is sexual orientation. Because of the expansion of Title VII to include protection for gay rights, it was no surprise that Virginia then also expanded its definitions. And so discrimination on the basis of a person's actual or perceived heterosexuality, bisexuality, or homosexuality is part of the act. Perceive referring to how others perceive that person. So if you're assumed to be of a different sexual orientation and you're discriminated against on the basis of that perception, that gives rise to a cause of action. Gender identity is one of the newer ones as well. Gender-related identity, appearance, or other gender-related characteristics of an individual with or without regard to their designated sex at birth. So that's now a new protected class. They expanded lactation, or actually expanded the definition of pregnancy, childbirth, and related medical condition to include lactation. Some of us have thought it had already been in there, but they just made it more clear, and they define what lactation is, which I think most of us know what lactation is, but they had to define it. And then veteran status. Federal law had always given protection to veteran status for decades, but now Virginia put it in Virginia state law as well. So some new actions that can trigger liability, and the cutoff is, with these amendments, employers who have 15 or more are prohibited not only from discharging, which was always the discharge, but now it's other types of what we call adverse employment actions. For those with less than 15 employees, the prohibition still only applies to discharge. So that's a distinction that needs to be made. So your larger employers cannot engage in these actions here in the smaller print. So failing to hire, limiting, segregating, or classifying applicants on any of the prohibited bases, using a protected class as a motivating factor in an employment practice. So you give raises to all the men, but you don't give them to the women, you're going to have a problem. Publishing advertisements that are discriminatory or that suggest a preference or limitation based on a protected class. Again, we only want women applicants. That's going to give you a problem. There's some exceptions to that if it's certain types of jobs, but for the most part, that's going to be deemed to trigger liability under the Act. You're going to have a problem with that. And what I just said, those employers 6 to 14 are subject to the provisions of the Act only for the discharge. There are new civil remedies that are now in place. Any form of discrimination, not just discharge, is going to trigger the right to bring the lawsuit with all the types of damages that we've been discussing. They, again, borrowed heavily from federal law, so they created administrative prerequisites to suit. So if any of you have been ever familiar with the Equal Employment Opportunity Commission at the federal level and the charge of discrimination, now there is a similar process that an employee, before he or she can bring suit under the Virginia Human Rights Act, will need to file an administrative charge with the Virginia Human Rights Commission. So, reasonable accommodation for childbirth, a couple things to note here. This applies to employers of 5 or more. So some was 6 to 14, but this is 5 or more, are required to provide reasonable accommodations to applicants and employees who are experiencing pregnancy, childbirth, or related medical condition, unless doing so would be an undue hardship. And then some of the examples they give straight out of the code, here's the code section, 2.23904, is more frequent or longer bathroom breaks, breaks to express milk, access to a private location other than a bathroom for expression of milk, acquisition or modification of equipment, or access or modification to employee seating, transfer to a strenuous position, assistance with manual labor, restructuring, modified work schedule, light duty, and then leave to recover from childbirth. The law sets out a specific requirement to engage in what it calls an interactive process with any employee who's in these conditions. So essentially, when the employee comes to you and advises that they're experiencing one of these conditions, there needs to be a back and forth. Well, what do you need? You know, do we need to get you a footstool? You know, something like that. Most employers, I think, do this already, but it's now codified by statute. And of course, there's an anti-retaliation provision. You can't retaliate against an employee who requests an accommodation. Also new, again, I think you're picking up on the theme here, a new cause of action. They can file in a general district or a circuit court for a failure to provide an accommodation, a failure to hire or discharge, or other discriminatory action. And this one, they don't have to file an administrative charge. I suppose because pregnancy can be obviously limited in time, they wanted to expedite the employee's right to bring this type of action. There's a 2-year statute of limitations. If they did file a charge of discrimination, perhaps they lumped in other areas, then it's within 90 days of a right to sue letter. So again, very much like the federal proceeding. A new gotcha point for employers is not only a posting requirement, but to include the provisions of the law in the employer handbook. So that's something new. We went and put it in our employer handbook when we did ours. You have to provide the information about the requirements for accommodation and the interactive process to new employees, or within 10 days of an employee advising you of the pregnancy. And again, right now, there's no specific approved summary of the law on the Virginia Department of Labor website. You would simply print the statute and put it in your room where you keep all your other employer notices until such time as they create one. Of course, there's always these companies that want to sell you the posters with everything on it. So you just have to vet those and make sure you have it in there. But the biggest provision is most employers more than likely did not have these items in their handbook. And so they now have to be included in the handbook. Okay, so what do you do with all this? Well, certainly you go back, you need to study your EEO policies, look through your internal complaint procedures, your termination procedures, provide training, particularly to your supervisors and your managers on the requirements of the law, comply with the posting requirements. If you're using independent contractors, you really need to look at that. And I think I failed to mention this. What the law will look at now is the IRS's 12-point checklist to verify if someone is truly an independent contractor versus an employee. There were a litany of tests by various governmental agencies, but the legislature chose to use the IRS's 12-point test. And so if you have someone in that situation, we could certainly review that. Two of the biggest things is, are they truly a separate business? Do they have their own business license? Things of that nature, versus is it really a laborer who just wants to be paid under the table, you know? But the independent contractor issue is something that could really come up and bite the employer pretty badly. Your job descriptions, make sure that those are updated. Provide a whistleblower protection policy. I think, again, this gets to updating your employee handbook. And if you're using non-competes and non-disclosures, definitely should review those and perhaps update them as well.